And we are, before we turn to paid family leave, we're going to look at a brief amendment. Sorry, to H217. It's called breakfast getting stuck. Okay, so we're going to turn to an amendment for H217 that Chair Marcotte has asked us to include, and sort of had thought we were including, which is the data that asking the Department of Labor to collect the data for 4 years so that we actually can have a discussion for the sunset review, so that there's any data to review. So Damien, would you be kind of just to go through this very brief amendment, and because this is going to be on the floor either fairly soon.
Yes, so for the record, Damien Leonard, Office of Legislative Counsel. So I've drafted this as an amendment from Senator Harrison because she will be the presenter of the bill on the floor. And it's drafted as an amendment to be offered at second reading. So it would be amending the report of the committee. If you decide to offer it at third reading, we can just change the header either with the Secretary's office or before it goes over there. So what it would require is on or before January 15th, 2027, that DOL in consultation with financial regulation would submit a written report to this committee and your House counterparts regarding the impact on the workers' comp system of the increase in the dependent benefit that's enacted. It would include an estimate of the number of claims that have received additional benefits and the additional costs to the workers' compensation system of those benefits. And then the final change would be to propose that the title of the bill be amended to an act relating to miscellaneous workers' compensation and unemployment insurance.
Thank you. Thank you. That was Wendy reminded us that we needed to do that. So that's great.
Yeah.
Thank you for doing it.
So that's it for the amendment.
Just one question, then I'll make a motion. So when we say additional costs, we mean additional costs to the insurers. I would hope that we also mean any costs that translate into additional premium. Like the first instance of costs and how they impact the.
Well, I think that's the concern is that this is going to have a big impact on employers. Is it going to have a big impact on the system?
Right.
And Mike
So
doesn't make costs.
Yeah. So I left the
Okay.
language deliberately broad.
Okay.
To allow them some flexibility to say, for example, in terms of dollars, we're seeing this, but the reports we're getting are that administratively, this was a huge challenge.
Okay.
Adding it to temporary partial disability. I'm not sure the extent to which they'll have all of the information they need to give a firm number, which is also why I've said an estimate of the number of claims and the additional costs. So it's reflecting too that they may have imperfect data.
Okay.
But yeah, I deliberately worded it broadly, particularly in the interest of time.
Right.
So
Perfect. That's great. No, because we don't want to be too specific and leave something out.
right.
So no, this is great. So
Thank you,
I'll
Damien, for doing this.
And the other thing too is if you start hearing anecdotally that there's a particular issue or there may be a particular issue, we have 3 years to amend this session law before the report is due.
Okay.
So we can always revisit this next year and rewrite the section
Okay.
if there's additional information we realize we need.
Okay. Sounds good. So I make a motion to propose to the House that our report be amended as shown in draft 1.1.
Great.
So now I will call the roll.
Yeah, or we could do all in favor.
All in favor, signify by saying aye.
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 Thank you. Sorry about that.
Acacia.
And Keisha, are you joining us?
Yeah, sorry, I was having a hard time unmuting, but aye.
Okay.
Perfect, thank you. So it's 5:00.
Great, terrific. Thank you. I'm sorry we could have easily embedded this, but there we are. Deal with requests when we get them. Thank you, Wendy, for carrying the water on this. This is terrific. And it will be either on the floor on Friday or Tuesday.
It might.
Yeah.
Pro Tem is trying to clear log. At this time of the year, you might be prepared to present it a little early, because depending on what they do with clearing, they can take it off the calendar and off the notice and move it up.
Right.
Okay, I'll do my best.
Yeah, we'll chat further about that. Okay, so this morning we are going to turn back to a bill that's an important bill that's in our committee. And whether I think we need to just at least finish the work that we began by fully understanding the bill before us, which is the paid family medical leave bill that has come to us from the House. We have already dealt with a significant piece of it, which is the parental leave sections in the childcare bill. And so we are, I can't remember where we finished walking through it. It seems like a very long time ago.
Did we ever walk through?
Yeah, we did. We started.
We started,
And I have it, and
but we did, it was the, I don't know, the 85,000 foot Q2 spy plane view.
yeah,
I took some grainy black and white photos of the bill for you and kind of presented the big picture.
That may be why I don't have a clear picture.
The money for this is not in the bill, is that correct?
So the appropriations committees are dealing with moving the money around. So there is an appropriation in this bill. Because this bill is unlikely to make the finish line this year, I don't believe it's reflected in the Senate's version of the big bill.
It's not.
Which means that the conference committees will be working with that money. So, yeah, and the Senate's version of the big bill, I think, included money for the parental leave program as part of childcare. The House's version of that bill doesn't include the parental leave. So there are a lot of moving pieces here, which I assume
The assumption that this bill is going to pass the Senate, or is it going to get that far? I don't think
at
it is.
this moment,
this year, I can't imagine that's the assumption.
Yeah.
the assumption is that this bill will probably the parental leave pieces are in play.
Mhm.
The rest of the bill will be worked on probably next year, is I believe what the work is that we are being given to do. So I think, given where you were, why don't we look at the sections that aren't parental leave, because I think we're pretty
It's
clear.
all woven together.
Oh, it's all woven together. Okay.
So, right. So what I'll do is I'll take you through the bill. I'll try to stay high level because we only have an hour.
Yeah, and we will be turning to this again in January, but
Right.
depending on how things play out, it's important for us to understand what we're leaving on the table for next year.
So,
And we
right.
may have to take up at a moment's notice.
All righty. So the first 5 sections of the bill relate to the existing unpaid job protected leave laws. So this is your job protection under existing law. If you need to take a leave to care for a family member who's ill following the birth or adoption of a child, or because of your own illness or injury that occurs outside of work. So the House is proposing, as you'll see in section 1, to add bereavement leave to that job protected leave. this would be leave both to following the death of a family member that occurs not more than 1 year after the family member's death, reflecting that particularly during the pandemic, many people had the experience of a family member dying and then waiting several months to have a memorial service when the family could get together. So the House left in that 1 year time frame. It also includes leave that can be taken more than a year or during that year and then more than a year after the family member's death in relation to administering or settling the deceased family member's estate, reflecting that sometimes that can be a quite time-consuming requirement for a family member that goes on for quite some time. Importantly, that leave is limited to 2 weeks a year. So the rest of the leave allows you to take up to 12 weeks a year. You can use 2 weeks of that 12 for bereavement leave purposes, assuming that you have a bereavement leave purpose. So in all of these cases, you have to be able to document that you actually need the leave. So that's something to keep in mind throughout this. We'll talk a little bit more about documentation requirements there in the next section. But it's something to keep in mind. You can't just say, my uncle died. Your employer can say, can you provide a death notice? So that, and I actually think your uncle's not even a covered family member.
I was going to say, it's like a step away.
Anyway, that was a bad example, but so I just wanted to highlight that because that's a significant change from the underlying law. The next thing to note is that we're defining domestic partner. So the definition of family member is being updated, as we'll see in a moment. It includes domestic partner now. Domestic partner is defined to mean exactly the same thing as it does for purposes of your disclosures as a political candidate. So we've kind of standardized that definition of having shared a residence, having an enduring relationship of a spousal nature, where you share a residence and have done so for at least 6 months. You're an adult, so not under 18. You're not married to or considered the domestic partner of another person. You're not related closer by blood than would bar marriage under state law. And you've agreed between yourselves to be responsible for each other's welfare, this recognizes relationships where individuals have decided not to get married or not get a civil union. So that's being added to the definition of family member. You'll also notice on page 2, line 7, that we're adding definition of domestic violence.
Yeah.
So we're adding what's commonly referred to as safe leave, which is leave to escape domestic or sexual violence. And then for purposes of the employer definition, you'll see a lot of strike through on page 2. That's really because we've just simplified employer from this long list of possible entities to a person, which means a natural person, a corporation, or any other legal entity. So it recognizes all of the various business entities that could be there, rather than saying this super long list that if you look closely at all the statutes that use that list, they all phrase it slightly differently. And it's raised a lot of questions over the years as we've been returning to this law. So we're just simplifying the definition.
And standardizing it.
And standardizing it. This would be the first step towards starting to standardize it across some of these statutes. And then in that employer definition, you'll see that in addition to the bereavement leave and safe leave that I've mentioned, we're also adding leave for a qualifying exigency, which is currently provided under the Federal Family and Medical Leave Act. what a qualifying exigency is it's leave related to the deployment of a family member who's in active service in the armed forces. So this could be leave to arrange for childcare, to arrange to move the family, to take care of family affairs at home that need to be dealt with before the family member deploys. It can also be leave for ceremonies related to the departure or the return of the family member from deployment. And we track the federal definition. So we're consistent with the federal definition. As a practical matter, what this does is it means that employees in Vermont who work for employers smaller, that have fewer than 50 employees, will now have access to this leave. So currently it's only employees at a very small percentage of Vermont's employers have access to that leave under the federal law. This will extend it to, in the initial phase of the bill, employers that employ 10 or more individuals for an average of 30 hours a week. So this will be roughly 20% of Vermont employers will be covered in the initial phase. You'll notice that in sections 4 and 5, this is extended to all employers in Vermont. So that is another significant change in the bill.
So first step is 10 or more.
10 or more for an average of 30 hours a week. So it's, if you have 10 employees who work 15 to 20 hours a week, you're not covered. If you have 10 full-time employees, you are covered. So that's the difference there. It keeps some of the seasonal establishments that might hire a lot of part-time work out of the coverage under the law, as it's currently phrased.
But does that get extended to those employees in later years?
It will.
Does it get extended even to the point of a person who employs one employee?
It does.
So I have one employee and that employee can be gone 12 months, 12 weeks of the year
Under
a combination or.
right, so that's proposed to take effect when the House's paid family leave plan will take effect. They would extend the job protection to all employees in the state, regardless of employer size.
Does that include part-time employees as well?
It does. So there are some restrictions, and I'll get to those in a minute. I don't want to try to do them from memory, because it's been a while since I looked closely at the bill, but there are some limitations on that. But part-time employees, some part-time employees will have access to that.
Employers going to be charged and pay for this leave, right? This is funded on the payroll tax.
It's funded by a payroll tax. So yeah, we'll get to the mechanisms there in a moment, but there is a payroll tax that will fund it. The employers will be held harmless for the unemployment insurance impact of hiring a temp and then laying the temp off. But there are some policy questions around size of employer. Some of you will probably remember that the Senate's version last biennium, or the Senate proposed and the House accepted a version where employers above a certain size were required to provide job protected leave. Employers below a certain size were required to provide basically a option of first refusal to a former employee if a job came open.
Remember those discussions.
But weren't required to provide job protection.
Any discussion about the ability to hire someone for 12 weeks, considering that most establishments are having trouble hiring anyone full-time, and to get an employee for a very short period of time might be a little difficult.
I don't recall the specifics of the House discussion around this issue.
But we will have a further discussion
Right.
and Senate will weigh in when we have time.
Mhm.
So
So-
now we're just trying to get here for the first time and get ourselves
So,
done as we will.
under the current law, to be covered as an employee, you have to have been employed by your employer for a year and have worked an average of 30 hours a week during the year. The only exception to that in the bill would be for safe leave purposes, where it would be work for your employer for 6 months for an average of at least 20 hours a week. So safe leave has a lower threshold. Otherwise, under the current law, that kind of answers your question on eligibility. If I work 15 hours a week for my employer, I don't get job protection. Or if I've worked only 3 months for my employer, I'm not entitled to job protection, unless my employer decides otherwise. So the next major change here, I'm going to try to keep moving here because I'm
Yeah. I
at
know
this
you've
rate,
got
we'll-
half an hour, yeah.
at this rate, we won't get there. The next major change is under existing law, we've referred to it as a serious illness of the employee or the employee's family member. That's being changed to serious health condition to track the federal FMLA.
So we're on page 3.
Yep, we're on page 3. The serious illness term has created confusion for employers and employees, and the House had testimony from an individual whose spouse had initially been denied leave when their son had suffered life-threatening injuries because the employer said, yes, because their employer said, well, that's not a serious illness. But it was if you looked at the law and how it had been interpreted, and the employer eventually changed. And then also if you looked under the federal FMLA, they would have been protected for that. So we're aligning with the federal FMLA. The other thing that this does is Vermont law, when it was written, had said, had required for the definition of serious health condition, that it be certified by or be under the direction of a physician. The reality for many Vermonters is that you no longer have an MD as your PCP or your primary care provider. You may have an advanced practice nurse practitioner, a physician's assistant, an osteopath, a naturopath. And in addition, we had a religious discrimination issue in the law because Christian scientists will see a Christian Science practitioner, and that is recognized and permitted under federal law. And Vermont law on the surface didn't permit that. So it was actually, we were potentially facing a religious discrimination issue that could have been challenged under the US Constitution. So this clears that issue up by switching to the federal definition. It also creates a more consistent playing field for employers, so they don't have to try to say what standard applies. So we track the federal standard more closely under the new definition.
Got it.
So the parental leave is expanded to really clarify a few things. So recovery from childbirth or miscarriage and the employee's pregnancy are expressly called out. So this relates to issues where your doctor puts you on, or your midwife puts you on bed rest prior to the birth because of complications. Or otherwise makes it so you cannot work. And it also addresses issues of both recovery from childbirth and miscarriage, which can require its own recovery period depending on the factors. And so that's something that previously would have had to either been argued was implicitly included or was covered as a serious health condition. And this clarifies that it's included and again, is consistent with the federal law on this.
If you wanted it to be a health condition, if it was better for the employee for it to be a health condition, or would there be any difference?
It doesn't provide a difference
Okay.
under the law. You get 12 weeks, period.
Either way, okay.
Um,
Or total for all of the.
Total for all of it. So the issue with serious health condition is because that's aimed at illnesses or injuries that require you to be inpatient, that are life-threatening, or that require you to receive in-home care under the direction of a medical professional.
Okay,
So the goal was really to make sure that you wouldn't run into an argument if you're recovering from a miscarriage that, well, it's not really a serious health condition, so I'm not going to give you the job protected leave. And the feeling was, let's just call it out explicitly in the
Okay.
law.
that makes sense.
So the other things that are called out explicitly is bonding within 1 year after the child's birth. That's entirely consistent with the federal law. Adoption was raised from 16 years to 18 years of age or younger. And that's adoption. And now the law would add coverage for placements for foster care as well. And so that's all called out. So the next thing is updating the definition of family member. And I just want to note, the reason I'm spending so much time on this is because this is consistent too with the paid leave program. So understanding these definitions will give you grounding. So family member has been expanded here. Previously, we would list, the list was the employee's child, stepchild, or ward who lives with the employee, their foster child, their parent, spouse, or a parent of the employee's spouse. So that was the cluster covered by family member. The new definition is significantly expanded. It includes, regardless of age, an employee's biological, adopted, or foster child, their stepchild or legal ward, a child of the employee's spouse or civil union or domestic partner, a child to whom the employee stands in loco parentis, which means in place of a parent for anyone who doesn't speak Latin, or an individual to whom the employee stood in loco parentis when the individual was under 18 years of age. So in loco parentis is the term used under federal FMLA. So we've just used that to be consistent. And we use the federal FMLA definition of the term in the law. So the language here was expanded to clearly call that out. The regardless of age is where we depart from federal law, which provides protection for children under 18. And this again gets to actually the issue that constituent brought in, where their child was in their 20s, but was facing a life-threatening injury and needed care, and their parents were the only people available. So the House felt that it was important to extend the leave to children regardless of age, because even when they become adults, as a parent, you may still be their primary person to provide care if they become injured or ill. So
They're still your children.
yes. And then the parent of the employee or the employee's spouse, civil union, or domestic partner. And then specifically providing, regardless of whether the relationship with the employee or the employee's spouse or partner is a biological, foster, adoptive, or step relationship. A legal guardian of the employee or employee's spouse or civil union or domestic partner, a person who stands in loco parentis for the employee or who stood in loco parentis when the employee was under 18, a person to whom the employee is legally married under the laws of any state or a civil union or domestic partner, so any form of spouse, A grandparent, grandchild, or sibling of the employee or employee's spouse or partner, regardless of whether the relationship is biological, foster, adoptive, or step. Or, as shown by the employee, any other individual with whom the employee has a significant personal bond that is or is like a family relationship, regardless of the biological or legal relationship, under the totality of the circumstances surrounding the relationship, including evidence of shared financial responsibility, which would include a shared lease, common ownership of property, joint liability for bills, beneficiary designations, evidence of responsibility for the other person's well-being, including emergency contact designations or an advance directive, evidence showing an expectation of care created by the relationship or the prior provision of care, or both, cohabitation for a period of 6 months or geographic proximity, and other similar evidence demonstrating a significant personal bond. So with that last one, there are really two things the House was trying to capture. One is some of the unique sort of found or chosen family relationships that particularly members of the LGBTQIA community have found themselves in that haven't been protected, where they act as family for each other, but when it comes to getting permission to care for each other, the law has provided blockades or blocks to that. And there was some evidence provided by some members of the House and other witnesses who spoke about some of the challenges they've had, where, for example, there was a couple where the children were donor conceived children of one member of the couple, and the other member of the couple may not have legally adopted the children, but then may be standing in place of a parent, but then concerns about that being recognized. And so this is providing protection for that. The other piece that was concerning here is instances where, for example, you have an elderly neighbor that you've become, they don't have family, and you've become their de facto care provider, taking them to appointments, providing care at the house, et cetera. And this, again, that's the geographic proximity, beneficiary designations, et cetera, where you've become their de facto family in their final years, and helping them sort of navigate through that. So again, there's a variety of evidence that needs to be provided here. It's going to be a case-by-case determination. This generated a lot of discussion in the House, and I'm sure when you take this back up, you'll have lots of questions and discussion on it, but that gives you sort of an idea of where this came from. And it has been enacted. This is based on the Colorado law and the Colorado regulations implementing that law. So the House combined the two into what you find here.
Which the Colorado law was enacted when? A while ago.
A couple of years back, and it's just being implemented now.
Okay, right.
So, all right, I'm going to
Healthcare provider.
skip ahead to page 6, safe leave, because we've talked about healthcare provider. We've talked about in loco parentis and some of the others. So safe leave includes leave because the employer or the employee's family member is a victim or alleged victim of domestic violence, sexual assault, or stalking, and the employee or the employee is using the leave to seek or obtain medical care, counseling, or social or legal services for themselves or a family member, to recover from injuries, to participate in safety planning for themselves or a family member, to relocate or secure safe housing for themselves or a family member, to meet with a state's attorney or law enforcement officer, or to attend a hearing concerning an order against stalking or sexual assault when the employee seeks the order as plaintiff. That last one, little Roman numeral 6, is already existing law. And you'll see in section 3 that we've taken it from the existing law and moved it here. And then the employee cannot seek this if they are the perpetrator or alleged perpetrator of the domestic violence, sexual assault, or stalking, recognizing that often this is immediate family, unfortunately, who is the alleged perpetrator. So you can't seek the leave if you were the one who committed the alleged crime.
Okay, but the alleged crime gets committed. I am accused, I didn't do it. The person that was hurt gets time off to go to court. Do I get time off to go to court, or have we prejudged that I am guilty?
So this is something we discussed last biennium. The answer is under current law, no, you don't get job protected leave under the law. Your employer could provide you with time off. Senator Benning, as some of you may remember, proposed a bill that would have extended it to anyone who has an obligation to appear in court, whether that's jury duty or because you have a case pending in front of the court. And so there was a bill last biennium. No one's taken that up, but if any of you are so interested, the language is ready to go.
Yeah, it just seems that in safe leave, there is a presumption that one party is innocent and the other party is guilty, but that party isn't guilty until found to be so.
So yeah, the place to put the court leave would probably be in our crime victims leave statute, which again assumes that the alleged crime victim is the victim of a crime and needs the time off, but doesn't provide time off for individuals to defend themselves. And I'm paraphrasing Senator Benning's explanation for his bill last year. And so, his argument was that as an attorney that defended a lot of people, many of his clients were found not guilty, but they didn't enjoy the same rights to defend themselves against the accusation as someone who was allegedly the victim of the crime. So it's sort of a tangential issue to this bill,
Right.
but it is something that you may want to consider next year or look at again. And like I said,
Doesn't feel like there's much that's been left out of this bill, so.
It's inclusive, our arms are wide
In
open.
for a dollar, in for a dime.
All right.
In for a penny, in for a pound.
So the serious health condition definition on page 7 is extended to an accident, illness, injury, disease, or physical or mental condition that poses imminent danger of death, requires inpatient care in a hospital, and we've added hospice or residential medical care facility, or requires continuing treatment by a healthcare provider. We've taken away the words in-home care. And then we've replaced physician with healthcare provider, and also provide that rehabilitation from an accident, illness, injury, disease, or physical or mental condition is included, including treatment for substance use disorder. And these are things that are protected under the Federal Family and Medical Leave Act.
So this is,
And
again,
this
sort of
is
truing up with the feds.
Truing us up with the feds. The language is not identical to the Federal Family and Medical Leave Act. The House wanted to specifically call out things like hospice and residential medical care to make that clear. With the FMLA, you have to do a fair amount of digging in precedent and regulations to find some of that language.
The FMLA, we're truing up our definitions with theirs, but theirs is for employers above.
Theirs is for employers with 50 or more
With 50 or
employees.
less, which is like
Vermont.
4.
Yes, so the difference is we are taking that and we are dropping it down to basically, if you employ anybody.
So the sections 1 and 2 is taking the existing Vermont law, which is 10 or more for everything but serious illness or injury. And that's 15 or more. And like I said, it's employees who work an average of 30 hours a week or more are the only ones who are counted for this. So that's worth noting is sections 1 and 2 are doing that with the existing law. Sections 4 and 5 are the ones where we're going to take it to all employers and all employees, or most employees. And I'll get to that in just a second.
Okay.
So with section 2, I'm going to skip over this because I've discussed most of the changes here. It is primarily truing things up and adding explanations, for example, of how soon you have to provide notice if you have an unanticipated leave, and the types of documentation that can be required for or provided to for a safe leave, as well as a bereavement leave.
Qualifying exigency stuff.
Yep, and then disclosure of private medical information is also added here. So things that weren't necessarily thought of when the law was drafted in 1991. And then truing it up with the new pieces. Section 3 is just making the adjustment.
Page 13 for anybody who's following along.
Yeah, really page 14. We're taking the language that I mentioned earlier that we've added under safe leave out of the existing leave for alleged crime victims. And so that's the only change there. Now, section 4, on page 14, this is really the crux. So this takes effect when benefits become available under the House paid leave proposal. And I believe I got to look at the effective dates. It's been too long, but that's a few years out at this point. So this is a delayed effective date, but it will extend the definition of employer to all employers that employ 1 or more individuals in Vermont. And then the employee definition is, so it's extended to any employee who's been employed for 1 year for an average of at least 30 hours a week, or the safe leave 6 months or an average of 20 hours for an average of 20 hours a week, or has received payments for services from which the employer is required to withhold family and medical leave insurance program contributions during at least 2 of the last 4 completed calendar quarters, or has worked for the employer during at least 2 of the last 4 completed calendar quarters, and the employer is required to provide the employee with coverage under their private plan if they've opted out of the state program. So basically, you're entitled to this job protection if you're either eligible for paid leave or you meet the old requirements under the law. The reason why there's an either or is to reflect what happens if an employee, let's take a common pandemic era situation. An employee works for an employer in the New York area. They've worked for that employer for 8 years down there. The employer says, you no longer need to work in person at the office, you can work remote. They relocate to beautiful Vermont, and they're now working remotely up here. So they're now covered by Vermont employment law. So this would look at, have they been employed by that employer for at least 1 year for an average of 30 hours a week? If that's the case, then they're also entitled to job protected leave. So we're not inadvertently cutting out people who would be protected under the current law, but are not covered for paid leave. So they may not have access to paid leave yet, but they're covered with job protection. So
they get job protection. At some point, are all these remote workers that we're paying we are paying to be promoted.
We're paying for fewer now.
Yes. But,
We paid for a few.
all right, all the remote workers that are here,
Yes,
at some point, will they be entitled to all of the paid leave
once
statute?
they've paid in once they have 2 calendar quarters of contributions in the system, they're eligible for the paid leave.
But
I told
if
you,
this is a payroll tax,
Yeah,
can we tax their employer in New York?
they're being paid in Vermont for work performed in Vermont, so they're subject to Vermont taxes.
So we can tax a New York employer.
Yep, so in the same way that, so a long time ago, a couple decades back, I worked for REI, the sporting goods retailer. They are based out of Seattle, Washington.
Right.
I worked for them in multiple states around the country over the years, but I was subject to the tax law of the state I was working in each time
Right,
because I was working in that state. If I'm working remotely for an employer, and this is something employers have struggled with to some extent
Yeah.
since the pandemic, once your employee moves to another state and that becomes their base for work, you're subject to the employment laws in that state. So employers are now catching up on this issue that, for example, if you're an employer based in a state where it's FMLA and that's it, and then your employee moves to a state like New York or Vermont or another state that has more generous leave laws, you're now subject to those leave laws.
okay.
Same
But
thing
that
with,
employer does not have to consent to that, does he?
The
In
move.
other words, the employer
that's it.
does not have to allow an employee to work remotely in a state
No.
to which he does not wish to be part of those tax laws. And I've seen a number of ads, for example, that effectively say that.
right, so employers are free to hire people as they please, and they can say, we want you can work remotely, but you have to be within, if, say you're in New York, you have to be in the tri-state area so that you can come into the office when we need you to. Or they could say, what is it, Airbnb, I saw an article about recently where they say, you can work anywhere in the world. And we'll deal with that.
Oh, but
But
I've
it's
also seen
entirely
ads,
up to the employer.
yeah, that are very, very clear that this position is a remote position. However, it only applies to the following states.
Yep.
I
And
can see them.
They
wanting
can
to
do
do
employer
that.
could do that.
I've certainly seen ads like that.
Yeah, an employer is free to decide who they're hiring, provided it's not based on something that's prohibited by law, such as discrimination on the basis of, race or national origin.
Well, I mean, one of the
something like that.
arguments that you could make is a state that provides a significant amount of benefits that the employer has to pay for or accommodate, and if they don't want to do so, it becomes a disincentive to allow for remote work.
Yeah, I mean, that becomes more of a policy question. It's, that's something that may be something worth discussing if and when this bill starts to move forward in the committee. But yeah, I couldn't speak to the extent to which that's the experience in other states that are offering these benefits.
okay.
So, 20 minutes to go. We'll
Yeah.
get there, folks.
No, this is a
Um,
big bill and it's good for us to,
So the rest of the changes until we get to page 17 are just technical changes. On page 17, 2 things we're doing. So this is really a vestige of older versions of the paid family and medical leave bills. At some point in the past, there was the decision made that they were going to call it family leave when the benefits were available. So you'll see at the top of page 17 that parental leave is struck out just because the definitions of family leave and parental leave have been merged. So that's the only change there. It's just a terminology change, not a change in what's actually being provided. And then at the very bottom of page 17, you'll see that you can now use family and medical leave insurance benefits for wage replacement when this additional change takes effect. So again, this is tied to the effective date for the program going on.
Right.
And that brings us to the insurance program itself. So the program, this starts on page 18. Section 2051 establishes the program in the Office of the Treasurer. It's a new division within the Office of the Treasurer.
And can you give us the high level here? This establishes an insurance program that we are going to staff and that we're going to run, as opposed to, just to bring Wendy up to date, as opposed to contracting with an outside provider who would provide all of this work. At the
Right.
moment, that's what the House is.
Yes.
So,
Right.
yeah, so there are three options that have been discussed. This is one of those. The first is the governor's plan, which is simply bring private insurance in and use the state as a base for that insurance program to try to stabilize the marketplace. The second option was in last biennium's paid family and medical leave bill. That is, the state runs the program, but then uses a third-party administrator to administer the benefits in the program. This is similar to what Connecticut does. So in Connecticut, they have a very small staff at their family and medical leave agency. I can't remember what the title of it is, but then they contract with Aflac and another third-party provider to administer their program. Yes, I'm picturing the duck too.
I know.
But I just,
So-
I thought
Advertising
Aflac
works.
was really for a limited,
Oh, yeah, it's regular insurance,
Yeah.
not this, but.
no, but I mean,
I can
it's a
see where they
different
would-
form of
Yeah.
this, of insurance. It's more limited, okay.
Right, and then this is the third version, which is, so it's worth noting the private market version is being implemented in New Hampshire and then is going to start, the implementation is scheduled to start here in Vermont in July. The third option.
For state
So
employees.
that's, yeah, and that's the
So that's
governor's
already on
plan.
track. That's on track.
Right, and then the third option here is this program, which would stand up a program where the money is kept in a state trust fund or a special fund in this case, and it is staffed by the state and run by the state as a state operated benefit. And this has been to date the most common model for the paid family and medical leave insurance, and then it provides for an employer opt-out to purchase private insurance if they can do that more cheaply than participating in the state program. And that is also a fairly common construct employed in like California, New Jersey, New York, all offer that option to employers. And I think a couple other states, but I can't remember off the top of my head. So but the sort of backbone of all those programs is the state runs the main program. If employers can get a cheaper product that provides the same or better benefits elsewhere, they're free to do that. So we'll use.
Is the private market providing that, or are employers taking advantage of that in other
Some
states?
employers are. I don't know all of the details.
Okay, but it does exist.
It does exist, and some larger employers in particular are. I believe Google takes advantage of that because they provide those benefits across their company, and so they comply with the requirements in the states they're benefit based in, but they also are providing benefits to employees who might be working in places like Montana,
All over the place.
et cetera. So,
Okay,
Okay.
insurance spreads the risk. If we are only Vermont, we are a very small pool. And if we are doing all the insuring, then all the risk is on us, or not us, all the risk is on the employers right now. The state has no skin in the game in this one. If we allow employers to go off, then Global Foundries probably has something. So we take large portions out of the risk pool. We end up with where we are in health insurance, where the small group and individual market are so small, especially that they're unaffordable. The state has skin in that game, so we work at it. I'm just concerned about how much risk we're taking in a very small pool, and what happens if another COVID epidemic goes through and half the state goes out on some kind of leave.
I think those are serious concerns that we need to address when we take this up. But I think
Well,
that's
actually, I
so
think
duly
finance will
flagged.
take that out,
Yeah, so flagged.
but it is an issue.
Yeah,
And if there's
it's
a
huge.
fiscal note, that would be helpful.
Yep,
I don't know if we have time for that, but,
probably not, and not
Probably not.
today.
okay.
Yeah.
We've
But at least
got-
we could
Yeah,
get,
I would like, we did a bill last year and it failed to get overridden, the veto by one vote.
How big is
But
the
it
pool that we're
Didn't
spreading?
have this kind of
Just the-
reservations amongst
Versus
The
the
private
money
rates.
committees that I remember.
Okay, but to be fair, that bill had the same exact opt-out provisions.
Yeah,
So, in fact, the opt-out in this one is actually a little more restrictive. That one had much more flexibility for employers in terms of the program they could offer. This one provides a little bit firmer language. And much more is not accurate, but it had more flexibility for employers. This one is more restrictive, tracking with closer to what other states have done. But I've got 45 pages and 12 minutes, so
Yeah.
let me
Well,
pick up the pace here,
Yeah,
please.
yeah. I
that's
wanna-
great, and we can have you back to finish this, we haven't, but let's make as much headway as we can.
Section 2052 on page 19 sets up the special funds. I don't think we need to go into that in great detail right now. Section 2053 sets the tax rate, or the contribution rate, as it's called in the bill. This is a payroll tax. It is, an employer can deduct up to 1/2 of the payroll tax from employees' paychecks, and then they have to foot the bill for the other half. I'm sure you will have lots of discussions about where that cost actually, who bears the brunt of that cost next year. But anyway, it's a 50-50 split. And covered wages for purposes of the tax are wages up to 2 times the Social Security contribution and benefit base, which is 160,000. So that the benefit base, contribution and benefit base is 160,400. So we're talking wages up to $320,000 under current rates, and it will increase as that base increases. So nearly all wages in Vermont are covered. There are very few Vermonters who earn more than $320,000 a year, and only their wages above that amount will be exempt. And enrolled, so self-employed individuals can also enroll in the program. They're responsible for the full amount of the contributions on their covered work income, which is again self-employment income up to $320,000 or so. And we track the federal net self-employment income definition. So it's your self-employment income. It excludes things like for a builder, costs of materials that aren't actually, that you don't actually make as income. So you may have money coming in from your clients, but it's going right out to pay for the windows or the lumber, whatever it is. And that was the best definition they could find that tracks the different realities of different self-employed individuals. And it also keeps it consistent for self-employed individuals when you're tracking your income. So the contribution rate for the initial 6-month period, July 1, 2025 through December 31, 2025, is set at 0.55%. And then for calendar year 2026 and annually thereafter, the contribution rate is set by the director of the program up to a capped amount of 1%. At 1%, the director cannot set it above that, and it triggers an automatic report back to the legislature with an explanation of why the rate has had to go up to that amount, and recommendations for changes to the program to drop the rate. So that's basically set up as to allow the program to be largely self-regulating within that parameter.
So what's the initial?
0.55. So I'm going to again, skipping ahead to page 22, the contributions are withheld on wages in the same way that income tax is withheld on wages. So it's a quarterly payment by employers. And then self-employed individuals would make estimated payments in the same way they do on their self-employment income. There are documentation requirements around the benefits. So for a self-employed individual, you're either eligible for wage replacement, I'll call it, or self-employment income replacement based on last year's final return, or if you can provide accurate documentation of 2 of the last 4 calendar quarters, those 2 calendar quarters. Okay, skipping ahead to benefits on page 23. Up to 12 weeks of benefits in a 12-month period. And benefits are 90% of the individual's average weekly earnings, up to an amount equal to the state average weekly wage, which is currently $1,135 per week.
1,000.
$1,135. And that obviously adjusts every year. But it's 90% wage replacement, which was the round number arrived at to reflect wages minus FICA. So most of the wage replacement under this is taxable income. The exception is the benefits that are in the estimation of the IRS in the form of workers' compensation. So that's basically leave by the employee for their own illness or injury, as opposed to caring for a family member, birth of a child, etc. So,
And last time to the consternation of many of us, because of the cost, we excluded covering yourself and your own illness.
yep. So benefits, importantly, do not need to be taken in one continuous block. They're taken in 1-day increments and can be taken intermittently. So for example, if you're receiving cancer treatments or something like that require periodic treatments, you can take your day off for the cancer treatments, receive benefits covering wage replacement for that day, rather than taking sick leave or something like that you might take currently for your wage replacement. And it's important to note cancer treatments are covered for job protected leave purposes already. So I can get an intermittent FMLA and Vermont Parental and Family Leave Act leave to cover those treatments. But I'm responsible for figuring out with my employer either sick leave or personal leave or whatever leave I can use to provide wage replacement for those days to the extent that I have that paid leave available. Eligibility for the leave. You have to be currently an employee or an enrolled self-employed individual, so meaning a self-employed individual is enrolled in the program. You have to have earned wages or self-employment income from which contributions were withheld during at least 2 calendar quarters in the preceding calendar year. If you don't meet those requirements, you have to have earned wages from which contributions were withheld during 2 of the last 4 calendar quarters, and provided documentation of that income or made contributions to the funds. I'm sorry, that's during the preceding calendar year was the first option. So earned wages from which contributions were withheld during 2 calendar quarters, or self-employment income from which contributions were withheld on 2 calendar quarters in last calendar year. And the reason for this is because we're truing up against the tax return. Or if you don't have that, then you can provide documentation of your income during 2 of the last 4 calendar quarters. And so that provides, it addresses a concern that the Department of Taxes had, which is that they don't actually track by Social Security number until they get to the point of processing returns. So if you have 2 or 3 employers, all they're doing is taking the quarterly payments from the employers, and then at the end of the year, the employers send in the W-2 information to the tax department, and that's the point when they true up by Social Security number. So if you want to take leave before then, what you need to do, because the state won't have the Social Security number data, is provide, for example, pay stubs, or if you're self-employed, documentation of the income from those 2 calendar quarters, showing that you made the income and you pay the contributions on that income. And then you can go from there. And then you have to be unable to work for a qualifying condition. And you cannot be disqualified pursuant to Section 2065, which prevents double dipping with workers' comp under certain situations or unemployment. The application, it's pretty self-explanatory. You have to submit documentation of the need for leave. You can apply 60 days before or 60 days after the commencement of the leave, and benefits can be back paid to the commencement date of the leave. And that allows for individuals where, for example, if you had, for example, a car crash or a skiing accident that put you in a coma or left you incapacitated to the point where you couldn't file the application, you could then go back when you're later able to do so within the next 60 days, or have your person with power of attorney do so within the next 60 days, file a backdated application with appropriate documentation, and then get a lump sum covering the initial period of the leave. The time to approve the application is 10 days with an extension of up to 30 days. And that was recommended based on testimony from Connecticut. It had originally been shorter. And they said the one thing that they really wished that their law had was more time to process applications, because that was their biggest challenge, particularly getting documentation for some of the leaves. The benefits are paid every 14 days after approval of the application. Taxes are withheld from the benefits. I'm skipping ahead now to.
We are at 10:15.
Yes. Do you
So
want to
where
stop right
is the
there?
goods? I
We
think,
could stop right now.
I
at
think this
page
is a good-
30. This is the self-employment enrollment in the program.
I'm hoping that we will be able to finish this before we are adjourned. Because I think it's good to have at least this beginning to be under our belt as we work during the course of the all prepping for next session. So I think it's important for us to just have an appreciation for what's here. So, thank you, Damien. And before you go, so I think we're going to take our